Welcome to the Hindu editorial discussion. My name is Ryan Pinto. I am going to discuss on November 24th editorial. The, the points of discussion or the topics of discussion today are number one, Kerala Act curbing dissent. So Kerala has made a law, Kerala state had made a law which it backtracked now on curbing the dissent, on freedom of speech and expression. Second is international trade and India. So the second point second topic we are going to discuss is international trade and India. A lot of issues have been covered in the earlier editorials. We are going to see some more points on the situation of international trade and what is India's position today. And the third and the most important is interfaith marriages. So the first point or the first topic is going to be part of GS paper 2, polity. Second one is going to be international trade and India, that is GS paper 2 again. And finally, interfaith marriages is going to be part of sociology or social issues, GS paper 1, or you can take it in 2 or your essays. So when we talk about GS paper 1 or sorry GS paper 2, it includes polity, it includes governance. This editorial will help you also in your polity as well as in your essays. What is the importance of this editorial? Overboard, a very nice headline. Kerala has gone overboard with the law-making power they have. They have tried to even surpass the principles of the constitution. Even the Supreme Court says that fundamental rights are supreme. Now, what has Kerala done? Kerala disregarded a settled law while issuing an ordinance to curb abusive content. Kerala has sought to make amends by keeping in abeyance its obnoxious proposal to abridge freedom of speech by conferring unbridled powers on the police to arrest anyone expressing or disseminating any matter deemed to be or deemed to threatening, abusive, humiliating or defamatory to a person or a class of persons in any manner. So this law is giving unbridled powers, very large powers to anyone who is seen to be threatening, abusive, humiliating, defamatory. Now these words are very vague. It is very subjective. It can be used on anyone. If a person is speaking against the government, it can be taken as a threat or a defamatory thing. So it becomes very dangerous and freedom of speech and expression is in danger. It is incredible that a state government crafted a law with elements declared unconstitutional by Supreme Court in various cases. And especially you must have seen in the 70s when Supreme Court or the executive had where the judiciary had a tussle with the executive during the Indira Gandhi. Supreme Court had clearly said that from the Golaknath case 1967, fundamental rights are supreme. Ignoring a major apex court verdict on the law of defamation and which is repugnant to provisions of the IPC, a central law in two ways besides going against one provision in the CRPC. So what this state government's law has done, first of all, it has declared something which was earlier declared unconstitutional by Supreme Court. It has said that should be done in case of defamation. Secondly, it has changed IPC. It has touched or changed IPC and CRPC, which is actually in the hands of the central government. So let's see what this state government's law had done, which now the state government has backtracked and said that it will not be continued or it will not be followed, but they had done it. His defense that the amendment only targeted defamatory social media posts and would not curb reportage, political satire or expression of opinion is quite hollow. So the chief minister said that this law, he tried to defend the law saying that it was only for defamatory social media post and it will not curb reportage. So reporters, press, it will not affect them, nor the political satire or expression of opinion, which is very hollow. How do you differentiate between all these things? So, very important case you must remember. In Shreya Singhal versus Union of India 2015. So, it's a very important case. Uh, like we have the Keshavananda Bharati, the Golaknath, even the Putta Swami, which is recently. Remember, Shreya Singhal versus Union of India. The top court struck down Section 66A of the IT Act. The section had criminalized the sending of any message through a computer source that was grossly offensive, menacing, or caused annoyance, inconvenience, danger, insult, injury, and intimidation. So, in the 66A of the IT Act, any messages which was sent through a computer and which was offensive, menacing, etc., could face criminal charges. But in the Shreya Singhal case, the Supreme Court said no, you can't do that. The failure to define the offence narrowly fell foul of the constitutional protection for free speech and expression. These terms, if you notice, are very vague. Defamation, offensive, danger, insult. It is very vague, it is very subjective. So these terms need to be narrowly expressed, and then only you can bring these laws. The same judgment, for the same reason, also struck down Section 118D of the Kerala Police Act, which made causing annoyance in an indecent manner through verbal comments or on telephone an offence. And the same judgment in the Shreya Singhal case, which was for the 66A of the IT Act, same judgment was used in the 118D of the Kerala Police Act, which said you can't use these vague words to stop freedom of speech and expression. So just remember 118D of the Kerala Police Act and 66A of the IT Act. How does it affect IPC and CRPC? So we had seen it is affecting the center's IPC and CRPC, which only the center can amend. The new offence is also vaguely defined and is made cognizable, whereas criminal defamation under the IPC is non-cognizable. So the first is it is making the offence cognizable. Cognizable means without warrant you can arrest the people, whereas IPC says defamation is non-cognizable, but Kerala police is changing it to cognizable, which is not allowed. Moreover, while upholding the validity of the criminal defamation, the court made it clear that no police officer can register an FIR for the offence. It can only be prosecuted as a private complaint. Section 199 CRPC. Now again, it is the first offence, first thing we are seeing that they made it cognizable. The state is doing all this, remember, and it is saying the police officer should not take it as should not do an FIR. All this only the center can make changes. It is not the state who can make these changes. So how did this state law bring such a thing? It can be prosecuted as a private complaint for section 199 CRPC says no court shall take cognizance of defamation unless the aggrieved party files a complaint. Further, section 118A lays down a 3-year prison term. It is 2 years under the IPC. So they have also changed the 2 sections of IPC, that is cognizable and second is 2 years, and 1 CRPC. So this is the whole issue, and as I have told you, the Kerala government has backtracked. Very important is the Shreya Singhal case versus Union of India 2015 and the currently 118 of the Kerala Police Act. Remember this. The second issue is time for an Asian century. India's challenge is in securing a Atmanirbhar Bharat in the emerging world order. So we have seen a lot of editorials on the RCEP and how trade has affected the GDP or trade has helped in the growth of GDP. So all that we have seen. So it's a continuation of those editorials. In an irreversibly more equal world, the RCEP has immediate geopolitical and economic implications. So we are seeing it is time for an Asian century. We'll see what is the importance of this RCEP. With the West adapting to Asian rules. So first time you have the West adapting to the Asian rules and marking the end of colonial phase of global history. So it's a very important, you can say, milestone. India's challenge is in securing an Atmanirbhar Bharat in the emerging digital order, navigating the US China technology and supply chain clash. So we have the Asian century, we have India also talking about Atmanirbhar Bharat, not depending on anyone, navigating the US China technology and supply chain clash. Let's see the Asian led world order. The mega trade deal was led by ASEAN. So, the importance of RCEP is it was led by ASEAN, not by China. Association of Southeast Asian Nations, 10 countries are there in Southeast Asia, from Southeast Asia, and includes Japan and Australia, military allies of the US, all opting for the Asian century as they do not see China as a threat the way US does. So Japan as well as Australia, though China was present in this RCP, they joined because they do not see uh, China as a threat like the US sees them. ASEAN centrality rejects the current frame of the West setting the agenda. Now, ASEAN is important, and that is why this is the dominance of Asian countries. RCP's principles and objectives show individual countries to choose the scope and product. The first is it is ASEAN led. Second is it allows the individual countries to choose the scope and product categories for bilateral tariff schedules and excludes divisive issues like labor and environment. The new frame goes beyond transfer of goods and services, focus on integration and facilitating supply chain for sharing prosperity, requiring a very different calculus for assessment. So why RCP is important is it is allowing the individual countries to choose scope, product. It goes beyond the goods and services, focus on integration, share prosperity, rather than which we have seen in the earlier or the other organizations where the West was dominating everything. It was all for the benefit of the Western countries. So that's not the case in RCEP. RCEP's new rules on electronic commerce and could offset losses in declining trades in goods. So there are rules in electronic commerce. So whatever issues we have, so India has issues with the RCEP saying that it will be hurting our export, merchandise exports, goods export. But what the editorial is saying that the rules in electronic commerce will offset that. It will balance that. Atmanirbhar Bharat will leverage endogenous technology strength, data, and population. Both China and India are breaking the monopoly of the West in wireless telecommunication, in artificial intelligence, and other emerging technologies. India has also in the UN questioned Western domination, called for reformed multilateralism. So we have called for reformed multilateralism. We speak of multilateralism, but India should also be given its rightful place. The global governance role of the US is already reduced. The US Congressional Research Service report dated October 30 identifies four key elements of this role. So the global governance role of US is reducing, and four key elements are: number 1, global leadership; defense and promotion of liberal international order; defense and promotion of freedom, democracy, and human rights; and prevention of emergence of regional hegemons in Eurasia. So, when we talk about today's global governance, what are the 4 points you'll remember? First is global leadership. Second is defense and promotion of liberal international order, free international order. Third, defense and promotion of freedom, democracy, human rights. So when we say we have to be a global leader, we'll have to focus on these things. And fourth is prevention of the emergence of regional hegemons in Eurasia. The US now exercises power with others, but not over them. So it exercises powers with others, not over them. So you must just remember how the whole game is shifting towards or in the benefit of Asia. This is the Asian century. Our ASEAN led organizations are rising, like the RCEP, where China is also present. Sadly, India has not been a part. The doors are open. There will be talks in the future. Hopefully, they will join with India's keeping India's problems or issues in mind. So that way, we'll be able to join. But India can also benefit, as we have seen, electronic commerce and be a part of this global, or you can say, uh, reformed multilateralism. Atmanirbhar Bharat, despite its military pivot to Asia, the US needs India in the Quad to counterbalance the spread of China's influence through land based trade links. India, like others in the Quad, has not targeted China and also has deeper security ties with Russia. US, remember, is a part of Quad. You should remember Quad is four countries: India, United States, Japan, and Australia. And we have not, India has not targeted China, and we have good ties with Russia also. And US needs India for its pivot to Asia. For its dominance in Asia, US needs India. No country has become a global power relying on others. India needs a new strategic doctrine and mindset. We have drawn the wrong lessons on both intentions and capability of China. The Henderson Brooks Bhagat report uh, remains classified, but its conclusions are available. So we have drawn wrong lessons on both intentions and capability of China. With the Rafale aircraft purchase, India has recognized that there will be no technology transfer. So we have taken the Rafale aircraft, but not the technology. So there will not be any technology transfer. Military theater commands should be tasked with border defense, giving the offensive role to cyber missile and special forces based on indigenous capacity. So, a report says that we have drawn wrong lessons from China. Military theater command should be given border defense, offensive role to be given for cyber missile and special forces. Effective linking of economic and military strengths. The overriding priority should be infrastructure, including electricity and fiber optic connectivity. Self reliance in semiconductors, electric batteries, and solar panels, and skill development. So, when we speak about Atmanirbhar Bharat in an international scenario, we must understand we need a new strategic doctrine. We need to take the right lessons. We need to give focus more on the cyber, missile, technology, electricity, power, energy. So if we focus on these areas, then we will be truly called as Atmanirbhar Bharat. Otherwise, just focusing on goods and exports and imports, etc., doesn't work. Conclusion: the time bound upgradation of national capacity through Atmanirbhar Bharat should enable agreements with individual ASEAN countries. RCEP members have expressed their strong will to re engage with India, essentially to balance China. There are compelling geopolitical and economic reasons for shaping the building blocks of the Asia led order, which is not yet China led, to secure an Atmanirbhar Bharat and the place in the emerging triumvirate. So you must remember, in the Asia, strong emerging powers are, you have India on one side, you have ASEAN on the other side, and you have China. Till today, still today, it is, remember, Asia led growth, not China led growth. And India would need the help, or you can say not help. We would need to come with all of the other countries so that we grow together and don't just let China take the whole pie and be dominant in the future. So this is a very beautiful editorial on the issues with the Asian century and the benefits or the positives of the Asian century and how India can see should see an opportunity. Third and the most important one is on the this editorial is relevant for your social issues and your essays. A conspiracy against interfaith love. Laws to curb intermarriages are part of the communal agenda. So we have seen many states declaring that they will bring a law on the love jihad, etc., which is a part of a communal agenda. In India, intermarriages between people of different regions, caste, or religion have to a large extent been prevented by casteism, religious conservatism, and even fear of parental authority. In India, already it is prevented. Intermarriages are hardly, you will notice, it is hardly seen anywhere. Surveys, large and small, confirm that vast of the majority of Indians, between 95 to 99%, have arranged marriages, which are by nature intra-caste and intra-religious. So majorly the marriages are arranged, which is majorly again intra means within its caste and within the religion. Between 70 and 80% of Indians across all age groups and religions disapprove of intercaste or interreligious marriage. Already, the mindset is such that people don't want intercaste or interreligious marriages. So, let's go ahead. No evidence of love jihad. Starting in, so where this concept of love jihad came and how was this concept growing and rising, and which is resulting to bringing a law which might not stand in front of the Supreme Court, mind you. So what is this love jihad? Starting in coastal Karnataka and northern Kerala in the mid 2000s, some vigilantes claimed that Hindu Muslim romances were a well thought out conspiracy to seduce Hindu women in order to convert them to Islam and produce Muslim children. It was among these vigilantes that the term love jihad was bandied out. So it was in the mid 2000 that this concept of love jihad came, and it was again a very, you can say, a very it just a concept. There is no truth behind it. You will notice even in the Rajya Sabha and the Lok Sabha, that is in the parliament, the home ministry was not able to substantiate this. Even Supreme Court has not substantiated this. So this is a very hypothetical concept, you can say. But the conspiracy theory and term love jihad were exported to North India in the run up to 2014 general election. So it started with mid 2000s in Karnataka and Kerala, and then going to North India. The NIA probe was ordered following continuing claims in Kerala in 2018. Even NIA was looking for love jihad. In UP, whose current chief minister issued a public death threat to men he claimed were involved in love jihad, the police investigated 14 complaints. The NIA reached the same conclusion as the Karnataka CID did in 2009. So, Karnataka had done CID had done a investigation. Even the NIA did the investigation. There was no conspiracy to convert Hindu women. Nothing called love jihad. All the women concerned had married and or changed religion as independent thinking adults. Under the guise of the anti-conversion laws, a few BJP state governments have now announced their intention to make love jihad a conspiracy theory, a crime punishable by imprisonment. The conspiracy theory has evolved along the way, exercising choice. Now, what is the problem of this law if it comes? Characterizing Hindu women as dim-witted and easily led is socially more acceptable than the idea that a woman can love outside artificial social boundaries and exercise choice. Now, what is the issue behind the love jihad? that Hindu women in love jihad, you must remember, Hindu women are considered as girls or adults who are not able to select or have their choice. They are considered as dim-witted, and easily they can be influenced. How can we think this law is on this base or this platform? And it considered this as more acceptable. They don't consider that the women can also have their own choices and can go outside their artificial social boundaries. Using provisions of criminal law on rape and kidnapping, conspired to murder their daughter on or her husband or both. Now, many times in case of intermarriages, what has happened? They have used criminal law on rape and kidnapping on the boys of the outside religion. They have also used uh, conspired to murder the daughter or the husband or both. The Supreme Court affirmed in the case of Hadia, formerly Akila, and Shafin Jahan, that no one had the right to interfere in the marriage of consenting adults. So before this, we had seen on freedom, and I spoke to you about Shreya Singhal. Here you have to remember on the case on Hadia and Shafin Jahan. Supreme Court has given a decision that no one can interfere. The changes in the law proposed by a few BJP state governments, if they go through, will create a decidedly hostile legal environment for Hindus and Muslims to marry. If this law is brought in, it will bring a very hostile environment for Hindus and Muslims to marry. Not only marry, also love each other. So that's going to be an issue. Nazi Germany's Nuremberg laws prohibited sexual relations and marriages between Jews and non-Jews. So we can compare this in history with Nazi Germany. Violation of the law led to imprisonment and later incarceration in a concentration camp. Segregationist US and apartheid South Africa had laws prohibiting interracial marriage and sexual relations. So we can see how these uncivilized laws have been in the countries, and these countries have now thrown away those laws. In South Africa, the law was enforced through surveillance and police raids. In both countries, violations were punishable by imprisonment. So we are seeing these laws are not good for a civilized country, especially a diverse country like India. It will hurt freedom. It will hurt the spread of love. It will hurt human relation. So three things we saw. We saw first issue was on uh, you can say India and the relations, that is trade relations with the other countries. Then we saw the Kerala's Act on freedom of speech, and the third one was the law on love jihad, which is being thought about by various BJP ruled states, which should not or shouldn't be coming. So this is all for today's discussion. Remember, the art and science of asking questions is the source of all knowledge. Thank you.